So the previous lesson took an introduction to the subject of theft and broader the dishonesty offences in general. This lesson is now going to start to deconstruct each of the key component elements of the offence of theft, which is as defined in section 1.1 of the 1968 Theft Act. We noted that what theft essentially is the dishonest appropriation of somebody else's property with the intention to permanently deprive. And we also noted that sections 2 to 6 of the Theft Act then go on to talk about each of the key component elements, dealing with each of them one at a time and expanding on them and adding extra elements of interpretation. This lesson is going to talk about Section 2 of the Theft Act, which is the first element of interpretation, this being the concept of dishonesty, the dishonest appropriation of property. Now, this is a mens rea element of the offence, and it is one that has been given a sort of broad definition in terms of the provision, and then there has been some additional elements attached to it in relation to the common law, in relation to the case law's interpretation of the definition. So as mentioned, we took an introduction in the previous lesson to the subject of theft. This lesson is going to start talking about the key components of theft, first looking at the concept of dishonesty. So let's begin then. So we know already that section 1.1 defines theft as something that takes place when an individual dishonestly appropriates property that belongs to another with the intention to permanently deprive the other of that property. Section 2 then begins with the dishonesty element. It says that a person's appropriation of property belonging to another is not to be regarded as dishonest if he appropriates the property in the belief that he has in law the right to deprive the other of it on behalf of himself or a third person, or if he appropriates the property in the belief that he would have the other's consent if the other knew of the appropriation and the circumstances of it, or except where the property came to him as a trustee or personal representative, if he appropriates the property in the belief that the person to whom the property belongs cannot be discovered by taking reasonable steps. A person's appropriation of the property belonging to another may be dishonest, notwithstanding that he is willing to pay for the property. So this is quite an interesting thing that the legislation does, because what it doesn't do, as you can see here, is define dishonesty. It doesn't say that something is regarded to be dishonest in these circumstances. It in fact defines dishonesty in the negative. It rather says that things are not dishonest if they fall into these categories. So we get a negative definition of the offence, or at least of the concept of dishonesty, looking at the circumstances to which something is not dishonest rather than the other way round. And so we have to turn to the case law to give us a better indication of where dishonesty can actually be determined by the courts. So there are circumstances in which something is not dishonest. Simply, if you appropriate the property and you believe that you have a right in law to deprive that other person of it, that's one reason in which you could say that it is not being dishonest. If you appropriate the property with the reasonable belief that the other person consented to you appropriating that property, again, that's not dishonest in that regard. And then finally, if you appropriate the property with the belief that the person to whom the property belongs cannot be discovered by taking reasonable steps. This is, of course, in the case unless you are a trustee or a personal representative, which, of course, would represent a conflict of interest and so, therefore, a breach of someone's fiduciary responsibility as a trustee. So all of these circumstances are the reasons why you may not be dishonest in appropriating property. Let's think about this in terms of the case law then. The case of Crown and Gauche is one of the first cases that we look at to illustrate the idea of dishonesty. Now, I would like to point out straight away that this is a thing that is later overturned in a future case. So don't cite this as good law because it no longer is. But in response to this, it is just talking about the way in which the idea of dishonesty is developed in the case law. So the future cases that we're going to look at in a couple of minutes are going to be more important and more illustrative of the idea of dishonesty. But this gives us an insight into the mindset and the mental state of the courts in relation to the determination of this question. So this case concerned a surgeon who had been taking fees for operations which should otherwise have been free, and as such, and in relation to this, he was charged and he was then convicted under offences under the 1968 Theft Act. At first instance, the trial judge directed the jury that the determination of dishonesty, as defined in the 1968 Theft Act, was one of an objective test. They said that the question of whether or not this person was dishonest is a question of whether a reasonable person would deem the activity as being dishonest. This would be overturned by the Court of Appeal. The test for dishonesty, they said, was a two-tiered test. Remember, this would later be overturned in a future case. So it was a two-tiered test. Firstly, would a reasonable person determine that the conduct was dishonest? This is the first element that was in fact directed by the jury at the trial judge, but the trial judge didn't add this second element that the Court of Appeal did. They said that if yes, did the defendant know that people would regard this as dishonest? That is the second element of the test that is added by the Court of Appeal. Again, as mentioned earlier, this would be overturned in the case of Ivy. So let's move on then. So we get all the way up to the case of Ivy and Genting Casinos UK Limited from 2017, a Supreme Court case. This case was one in which a claimant had used a special technique in a casino which essentially exploited the design irregularities on the back of playing cards. The result of this was very successful. He would ultimately win over £7 million as the result of basically exploiting and basically, if we're being honest, cheating at a casino in the exploitation of the design irregularity on playing cards. When the defendant, the casino, then refused to pay this individual the $7 million, owing to the fact that they claimed that they had cheated, the claimant sued. They said, no, I was fully entitled to my $7 million. It's not my fault that you have design irregularities on the back of your playing cards. I should be able to take the money that I have won. The claimant argued that there was an implied term in the contract relating to cheating. Essentially, that it was implied that you shouldn't be able to win money in the casino through cheating, and that cheating implies an element of dishonesty. And he relied on the test from Gauche to argue that he did not meet the second limb of this test. So, essentially, the claimant says, I want my money, you're refusing to pay me my money, I accept that there is an implied term in the contract relating to cheating, but that the idea of cheating implies an element of dishonesty. So, let's think about the element of dishonesty. Dishonesty, according to the case of Crown and Gauche, required both, firstly, whether a reasonable person would consider me to have been dishonest, but secondly, whether I myself would have been considered or reasonably believed that I was being dishonest in my conduct. This is the two-limb test of the Gauche case that we just looked at. Note here that we're not actually talking necessarily about a criminal case. This is a contracts case, if you will. And so as a result of which, the discussion of dishonesty does cross over from the criminal law to the civil law tradition. So make that very, very clear. The Supreme Court would disagree with the claimant, and so as a result of which would disagree with the dishonesty test that had been established by the case of Gauche. They overturned the second limb of the Gauche test and made it the determination of dishonesty, which would then be upheld in the case of Barton. The case of Crown versus Barton was a 2020 case involving a defendant who had been the owner of a care home. It was argued by a number of individuals and then by the Crown that he had acted in a way towards wealthy residents which had led them to leaving him money and property in their will. So he had essentially scammed, or he had essentially convinced a lot of elderly residents who were particularly wealthy that they should leave various different things, money and property, in his to them in his will. Sorry, to him in their will, should I say, and this would obviously be something that was considered to be dishonest. The number of transactions were notified, and he was therefore convicted of fraud as a result of this particular actions. Notice again, we're not even talking about theft; we're talking about fraud, and so note that the concept of dishonesty transcends most of the offences that we're going to be talking about in terms of the dishonesty offences. Hence the name. The Court of Appeal then had to make a determination as to the nature of dishonesty, as you would think. In upholding the case of Ivy, and as a result of which dismissing the case of Gauche, the Court of Appeal held that the test for dishonesty is whether or not a reasonable person has acted by the standards of a reasonably honest person. The question of whether or not they personally believe they were acting honestly should be irrelevant to the matter. So the case of Gauche is dismissed, and the case of Ivy is upheld. In reality, the trial judge case in Gauche is actually the part that is upheld finally. So quite interesting. I'm sure that trial judge probably feels quite good about the fact that they have had upheld their basic principle of dishonesty, even though the Court of Appeal in that particular case had actually dismissed it. So the subjective test of whether or not an individual themselves believe they were acting honestly or dishonestly is irrelevant to any of the matters concerning dishonesty as codified in both Ivy and in Barton.